You asked for it, you got it. Duncan versus Bonta, a major win for the Second Amendment. Judge Benitez has indeed struck down, as I predicted, California's ban on magazines that hold more than 10 rounds. Excellent decision by Judge Benitez, but not a perfect one. He made this harder than it needed to be. We're going to talk about the great news in this opinion and a few ways that this can be improved going forward in arms ban cases. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box Diary, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the book that lays out how the anti-gunners intend to take away our guns step by step. Make sure you check it out because you got to know what they're trying to do to make sure they fail. All right, folks. I was away over the weekend at the Second Amendment Foundation's gun rights policy convention. It was a great conference. I really had a great time. I enjoyed speaking. We'll talk more about that in a future video. But that's what delayed me a little bit because I was out of town working on that and some other related issues. But here I am back and ready to talk about Judge Benitez's major ruling here. All right, so the bottom line is this, and this is the good news. Judge Benitez has held that California's 10-round magazine limit violates the Second Amendment's right to keep and bear arms. That magazines are indeed arms, and they are in common use by Americans for lawful purposes, including for self-defense. Now, he also pointed out that there is simply no historical analog law at the time of the founding, or frankly, at any relevant period of time, even through the Civil War, that Judge Benitez could find based on what was provided to him by the government that could possibly justify an arms ban at all, especially when it involves firearms. And of course, magazines are an essential component of firearms, or also help facilitate the use of firearms, so they're clearly arms. We'll get to that more in a second. Judge Benitez very meticulously reviewed every single one of the state's analog laws. They submitted somewhere on the order of magnitude, I think, of 500 different analog laws, trying to claim that one of these 500 laws justified the banning on these magazines because that somehow constituted a historical tradition of firearms regulation, i.e. a gun ban in this case. And Judge Benitez said undeniably that is not the case. Now, Judge Benitez issued this decision on Friday. He then said that he's going to stay, which means to pause the effect of his decision for 10 days, giving the state of California the opportunity to appeal on an emergency basis to the Ninth Circuit Court of Appeals. I'm not sure it's going to do him any good, but we will see in just a few days what's going to happen here. Okay, so now let's get into the geeky details of this decision. To begin with, overall, an excellent decision, but a major mistake by Judge Benitez. He made this harder than it needed to be on the Second Amendment plaintiffs and frankly, even on himself. Let me step back and explain. We've talked about this common mistake that the anti-gunners have been encouraging courts to engage in since the Bruen decision came out. Specifically, what the anti-gun community has been trying to do is to persuade courts, including judges like Judge Benitez, that Bruen is the law of the land involving the Second Amendment. And that is where you begin all analyses. That is not actually true. Remember, the Heller decision, the Heller versus DC decision from 2008 is the law of the land. The Heller decision set forth the methodology where you start with the text of the Second Amendment, and then you look to see if there's any historical tradition regulating or restricting gun rights, and that text first, then historical analog tradition analysis was actually done first and foremost in Heller in 2008. After it did that in the context of a gun ban, now keep in mind, Heller was an arms ban case because the case presented, the facts in Heller were that the District of Columbia banned a particular type of an arm. They banned handguns, which obviously is an arm. So what happened there is the Supreme Court did a methodology, an interpretive methodology, explaining how you interpret the Second Amendment. They start, of course, with the text of the Second Amendment, the right of, it says that the people mean all Americans and potentially even more than all Americans. That the right to keep means to possess. The right to bear means to carry. And arms means anything that can be used offensively or defensively, including, but not limited to, body armor. Those definitions help explain the text of the Second Amendment. And then, of course, anything that's necessarily implicated from that. For example, although the text does not mention bullets. The text of the Second Amendment does not mention triggers. The text of the Second Amendment does not have the word barrel. The text of the Second Amendment does not have primer or cartridge or any of these other words. Obviously, for modern day firearms to work, you have to have those component parts. They help facilitate the use of arms. So textually, those things fall within the definition of, let's say, arms. Okay, now let us carry on. That is the text. Now, as you know, in Heller, once the text was satisfied, meaning that a handgun was obviously an arm, and not being able to possess a handgun in D.C. was obviously implicating the right to keep a arm, i.e. keep a loaded handgun at home, unlocked, ready for confrontation. Once the text was implicated, the court then did a historical analysis to see was there any history in restricting any kind of guns. And specifically, they came back and says that the only conceivable historical analog that might apply in a arms ban case or a gun ban case involving the Second Amendment might be weapons that are both, conjunctive, both, dangerous and unusual. Dangerous and unusual was the only historical analog that the Supreme Court said might apply in the context and might justify an arms ban case. But because handguns were common, i.e. in common use by Americans, they could not be dangerous and unusual because they're in common use by Americans. Thus, they cannot possibly be unusual, and thus they cannot be dangerous and unusual. Conjunctive together test. So that is what the Supreme Court said in Heller. So what's happened, of course, is Bruen in 2022 did the exact same methodology, the interpretive methodology of the Second Amendment that it did in Heller. The only difference is that the Supreme Court was essentially spanking or scolding the lower courts for their bad misbehavior between the year of our Lord 2008 in Heller and the year of our Lord 2022 in Bruen, and essentially was saying in the Bruen decision, listen here, you inferior courts, as defined by Article 3 of the U.S. Constitution, you've got to get this right. We are going to give you a paint-by-numbers way to apply Heller, which will now be called the Bruen methodology, because we're taking the Heller methodology that you couldn't get straight. We're going to basically elaborate on the Heller methodology in the Bruen decision and give you a paint-by-numbers way to do it step by step by step by step by step, because in the last 10 years, you inferior courts have screwed up so many times, we're fed up with it. That is what's the key. So the reason why this is so important is because what Judge Benitez did here that was not right and actually harmful to the Second Amendment plaintiffs and the Second Amendment community is that he made it harder for the Second Amendment plaintiffs to win an arms ban case. And we'll get to the exact why he went wrong there, and it's very fixable, but I want you to understand this. So again, once you understand that Heller and Bruen are the same, explain the exact same methodology of text first, then you look to historical tradition of firearms regulations second, and then you look to potentially late 19th century confirmatory historical evidence that can confirm the 1791 understanding of the Second Amendment, but cannot contradict either the text of the Second Amendment or late 19th century evidence cannot undercut or contradict the 1791 historical evidence. Once you understand that, that is the interpretive methodology that courts are to apply. But here's the key. Here is where Judge Benitez got it wrong in a critical way, but no harm, no foul, because the outcome was correct, but his methodology was slightly off. Here's where it went wrong. The Heller law, the Heller decision is good law. The Bruen decision did not modify or undercut, I should say, Heller. Heller did the methodology of text and historical tradition, and that gave rise to a legal test. A legal test. That legal test is to be applied in arms ban cases, because the Supreme Court has already done the textual and the legal work in arms ban cases, gun ban cases in Heller. And that test that the Supreme Court came up with, which is extremely favorable to the Second Amendment community, is this. If an arm is in common use by Americans for lawful purposes, it cannot be banned, period, full stop. Here's the key. That issue of if an arm is in common use and it cannot be banned is the test. But here's the key part to understand. That test occurs at the historical level of the Heller/Bruen methodology. What does that mean? The text comes first. And we know what the text is. The right of the people to keep and bear arms shall not be infringed. All those words have been defined in Heller. We just went over that. Once the text is implicated by a modern-day gun control law, which obviously banning a magazine or banning a firearm implicates the right to keep and bear arms, right? That text is implicated. The burden shifts, this is key, listen carefully, the burden shifts to the government to come forth with historical evidence that shows they can regulate the arm and or ban the arm. But because Heller dealt with arm bans, it's already decided the test. There's no further work to do to figure out what is the legal test for an arms ban. That test is, again, if an arm is in common use by Americans for lawful purposes, it cannot be banned. That's the Supreme Court decision in Heller. And how did the Heller court come to that conclusion? If the arm is in common use, it cannot be banned. The answer is not at the textual level of the Second Amendment analysis. The in common use test by Americans for lawful purposes is a test that came out of the history part of the Heller analysis. And why is it so mission critical that I really want you to understand this? That the in common use test, meaning the in common use by Americans for lawful purposes, that test is a historical test that derives from the historical part of the text and then history analysis. Why is this so important? It is so mission critically important because the burden shifts to the government when you get to history. The text is implicated. As soon as that text is implicated, the burden shifts to the government, and the government must show that the arm they're trying to ban is not in common use by Americans for lawful purposes. The burden is on the government. That is a huge advantage that the Second Amendment community has, which is why the anti-gun community wants to take every single conceivable legal fight about the meaning of the Second Amendment and elevate it to the textual level of a Second Amendment case. Because at the textual level, as to what the right of the people to keep and bear arms means, it's more of an equal balance as to where the burden falls. Arguably, the burden could fall on the Second Amendment plaintiffs. But that's wrong, because once the text is implicated, the burden shifts to the government and they have to come forth with the history. The in common use test in Heller is part of the historical step. The reason why that's so important is, again, we want the burden to always be on the government to come forth with historical analogs. So the mistake that Judge Benitez made in this case, the way he did it is he underemphasized the fact that Heller remains good law and that the Heller in common use test is the law, and the in common use test is not part of the textual analysis, which is how Judge Benitez analyzed it as part of the text of the Second Amendment. That's a mistake. And that is not just a mistake. It's bad for the Second Amendment, because we always want the burden to shift to the government to prove something, because we know they really can't, because it's 1791, there's very few gun control laws outside of you can't use a gun to commit murder and the like. Okay? So again, by Judge Benitez elevating the discussion of that these magazines are arms in common use by Americans to the textual level of the text first and historical analog, he made it harder, because basically by doing that, he's essentially shifted the burden of showing that an arm is in common use onto the Second Amendment plaintiffs. But that is absolutely 100% wrong, because Heller's in common use test is part of the historical history and tradition part of the analysis. And thus, it's part of the analysis that the burden is borne by the government and not by the Second Amendment plaintiffs. And this is why it's so important. And Judge Benitez made this mistake. And again, no harm, no foul here, because he ruled correctly at the end of the day. But by not shifting the burden, by not saying that the in common use test is part of the historical part of that text, then history analysis, he gave the government a pass, because he did not shift the burden to the government to say, okay, you have to show us, government, state of California, that these magazines that hold more than 10 rounds are not in common use. That is your burden. The plaintiffs don't have to show these magazines are in common use. Now, obviously, we know they are. There's hundreds of millions of these. That's why they want to ban them. That's why every single anti-gun group talks about how there's too many magazines on our streets. They're already admitting that they're in common use, and that's why they want to be banned, because there's too many of them. So yes, in some ways, it doesn't matter because it's such an understood fact that there's so many, there's tens of millions or hundreds of millions of these magazines. Everyone has tons of these things all across the country. But it's still mission critical because what Judge Benitez did is that he basically gave the government chances to win the case that they're not entitled to. Because again, hypothetically speaking, if the plaintiffs had not come forth with ample evidence that these magazines are in common use, which I think everyone kind of understood as fait accompli they are, that could be a problem. Because again, it's not the Second Amendment plaintiffs' burden to show that something's in common use, because that's at the historical level. Because it's the historical level, the burden is on the government. Okay? So I want this to be very clear. For those of you involved in any appeal, you have to make this clear. The burden is on the government to show something that is not in common use. That in common use test does not occur at the textual level, it occurs at the historical level. And I apologize if I'm belaboring this point and being a little redundant here, but this is so important. And so many judges are making this mistake because the anti-gunners are trying to dupe courts to do exactly what I just said, which is they're trying to elevate every single issue involving the Second Amendment to the textual level. Then they're doing that because the burden has not yet shifted. And once that burden shifts to the government, they are dead meat on almost every modern day gun control law. And that is why the anti-gunners work so hard to try to avoid a historical fight. Okay, so with that said, I hope I'm not beating up Judge Benitez's opinion too much here, but I did want it to make sure that you understand that he made a critical mistake here, and he did this because he did not emphasize, I don't think he fully appreciated that Heller and Bruen are really the same methodology, and that the Heller in common use test has already been established for arms ban cases, and because this magazine ban is a form of arms ban case, all he needed to do was apply Heller. He did not even need to get into Bruen at all, because Bruen is dealing with things other than arms ban cases, because Heller is still good law and deals with arms ban cases. All other aspects of firearm regulation in America are really covered by Bruen, but arms ban cases is covered by Heller to this day and going forward because it's still the law of the land. Okay, enough about criticizing this part of the opinion, but this is so important. I really wanted you to get this right. Let's talk about some of the other great points he made. This is overall fantastic opinion. I would give him an A, at worst an A- for this decision, but I did want this point to be made. I think it's important. But let's go through some of the other really powerful gems that Judge Benitez writes here. I love the fact that he says that in a stealth return to the interest balancing test rejected by Heller and Bruen, the state of California ostensibly justifies its magazine limits by deeming the smaller magazines well suited for its citizens. Exactly right. Just now keep this in mind. The Heller decision, which is the arms ban case, this is what they wrote about handguns being protected. Quote, listen carefully, quote, "Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition on their use is invalid." Hear what I just said? Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense. It doesn't matter. You see, California's trying to come up with, well, this not, long guns are better, or this is better, or 10 rounds is enough. No, the Heller case, the Supreme Court said that whatever the reason is, Americans, we the people get to choose our arms. The government doesn't get to tell us what guns we get to own. It doesn't get to tell us what magazines we get to own. We the people, in our judgment, get to make this decision. That is what Heller said. Whatever the reason, handguns are the most popular weapon chosen by Americans. Our judgment prevails. And it's nice that Judge Benitez pointed this out, and that California is not allowed to try to tell Americans what they think is best for Americans. This is not like a Jewish grandmother saying, eat your broccoli, right? This is not anything like that. This is, you get to decide for yourself what weapons you get to own, and that is what Heller stands for. But let us continue on. Judge Benitez also says Quote, woe to the victim who runs out of ammunition before armed attackers do. The police will mark the ground with chalk, count the number of shell casings, and file the report, period, close quote. A hysterical line right out of probably countless books that I have written and others have written, that basically the role of police is to show up and take witness statements and draw the chalk line around the body. And it's great that it found its way into this opinion, because basically what Judge Benitez is saying is you are your own first responder. Police are simply not going to get there in time, because the cliche that says when seconds count, police are minutes away is oh so true. And it's great that Judge Benitez recognized this fact. I think that's great news. And again, it's completely true. By the way, I should note that Judge Benitez, in his opinion, gave a whole list of instances where people use more than 10 rounds in self-defense. And again, my point is police walk the same streets that we do, and they're carrying, 30-round magazines or 17 or 19-round magazines every day. And if they're walking the same streets that I'm walking, why do they need more ammunition than I do? They have they can't open fire on people except in self-defense, no different than I am, or I can. So why do they get some special privileges with these extra rounds that I don't when we're all walking down the same streets in California or beyond? I also thought it was very powerful that Judge Benitez specifically said that once you say the government has a right, a power, if you will, to dictate the number of rounds Americans can carry, then why can't they just go down to one, right? Nothing prevents them. What's the difference between 17 rounds, 15 rounds, 10 rounds? And he does a great job pointing out that throughout the country, different states have different numbers. Sometimes it's a 10-round magazine ban. New York, it's had 7-round ban at one point. Other states have 15 rounds. Some do one round set of rounds for handguns, another set of rounds for another number of rounds for long guns. And he does a great job saying this is just made up. There's no rhyme or reason to any of this. And at the end of the day, government, there's no historical tradition of restricting magazine capacity or capacity of any of these firearms. It simply is not there. Now, on this channel, we've talked about how the anti-gunners are trying to use things like Bowie knife regulations, but we've talked about this in detail. In fact, if you read the Benitez opinion, which I'll put a link to down below, it's going to sound an awful lot like the Four Boxes Diner. A lot of the points we make here in the Four Boxes Diner, you're going to sound awfully familiar when you read this opinion. Notwithstanding my kind of long colloquy there about how Judge Benitez could have done it slightly better, I don't want that to be taken as besmirching him in any respect. It's just a slight comment and recommendation about how to improve things going forward. But with that said, it's very interesting how Judge Benitez points out that in addition to the fact that these regulations on Bowie knives and other sharp instruments were not arms bans, more they were regulations about how to carry. We've done videos on this about how if you look at the history of Bowie knives, these were restrictions on how you carried them, not on the possession or you couldn't just, they weren't banning them at the time of the founding. You may have some restrictions on how you carry them, open or concealed, but at the end of the day, there was no ban on them. And again, the magazine is a ban case and, in common use applies. But beyond that, what's interesting is that Judge Benitez made a point that I guess I had never really focused on, and I'm going to just read you relevant language from Bruen. He does point out that the government must then, as you know, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. That's correct. Goes back to my text. And then what happens once the text is implicated? Then he goes on to say the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Right? We've talked about that. But firearm regulation is very interesting because he points out that and I had not thought of this, so Judge Benitez got one on me on this one. He said that all the regulations and laws dealing with knives and non-firearms are irrelevant under the Bruen standard. Because he says that the Bruen standard talks about the historical tradition of firearm regulation. Now again, he doesn't need to get into this at all because the Heller in common use test just needed to be applied. The burden needed to shift to the government to show that these magazines are not in common use, that it would be an absolutely impossible burden, and they would just lose right up there, and this opinion could have been half the length. But he really did go and show his work, and I'm giving him credit for showing all of his work and basically going through the whole analysis again. Even though he didn't need to do it, he did it and still reached the right outcome without a doubt. But I found it was interesting that he distinguished all of the knife cases as saying those are knife regulations and knife laws, but Bruen's talking about historical tradition of firearm regulation. And I think, that's another distinguishing characteristic between the knife laws and gun bans that I hadn't thought of. So kudos to Judge Benitez. The only two final points I want to make about how powerful this was, the government of California did indeed argue, as I predicted, they were going to bring back their old favorite, which is these gunpowder storage laws, to say that, see, at the time of the founding, you could restrict gunpowder storage. Gunpowder is the equivalent of like rounds in a gun, and therefore we can ban magazines and rounds in a gun over a certain capacity. We talked about why that is a hooey argument, silly, and Judge Benitez saw right through the state's argument and made the exact right point, which is that, no, that's not true. In Heller, they talked about how gunpowder storage laws were not about crime control or gun control. The why they were enacted is totally different. The gunpowder storage laws at the time of the founding were enacted. Why? The answer is because they did not want all the cities like Boston and Philadelphia and London, by the way, to burn down because they were all made of wood. So you were limited as to the number, the amount of black powder you could have in the town, because if that caught fire, it could wipe out the entire city, which did indeed occur every now and then. London burned entirely down before the founding of America, so people were well aware of the dangers of fire. But again, the why you were restricting black powder at the time of the founding had nothing to do with gun control, firearm regulation, or anything like that. It was a fire code consideration, and that is exactly what Justice Scalia wrote about in Heller when he basically disagreed with a dissent by Justice Breyer. In the Heller case, and Breyer tried to use the exact same arguments as Stevens, I forget which one it was, dealing with these black powder storage rules, and again, Scalia distinguished it, as did Judge Benitez, and that is right on the correct answer. They are not historical analogs to show firearms regulation involving bans on anything. These are fire code regulations. And the last point I want to make, which is quite interesting, the final point I want to make is indeed one of my favorite laws, the Militia Act of 1792. Remember, the Second Amendment and the Bill of Rights include all the other aspects of the Bill of Rights, like the First Amendment, were adopted in 1791. What happens in the year of our Lord 1792, a year later? Congress enacts the Militia Act of 1792 that actually required 18 to 45-year-old males to bring with them to militia musters their own weaponry. And what did that weaponry consist of? It included a firearm. It could be a musket, it could be a rifle, included black powder, cartridges, pouches, and the like. And how many cartridges did you have to bring? At least 20 rounds. So isn't that kind of interesting, right? The Militia Act of 1792 actually required Americans to bring their own commonly owned firearms and ammunition, and it was 20 rounds, which last I knew, by my math, 20 rounds that you're required to bring exceeds the 10 rounds that California wants to say you cannot have more than 10 rounds on you in your firearm. And Judge Benitez pointed this out, that says, not only is there no historical analog at the time of the founding that bans magazine capacity or bans the amount of rounds you could have. In fact, the laws at the time of our founding did just the opposite, which is to require Americans to bring 20 or more rounds with them to militia musters. And those were brought by Americans from what? Arms they were commonly using already in their private lives, that they privately own. That's where this in common use test comes, right? That Americans had these weapons in common use for lawful purposes, for hunting, for self-defense, for whatever, and it was those commonly used weapons that were brought with them to militia musters, including 20 rounds of ammunition and cartridges at the time of the founding. And Judge Benitez used that to say, how on earth can you possibly say that 10 rounds, that you can limit people to 10 rounds when at the time of the founding, people were not only allowed to have 20 rounds or more with them, they were actually obligated to under militia-related statutes as to what they were to bring there. Powerful evidence. And by the way, I just think this was kind of amusing. One of the funniest parts of the Judge Benitez decision here is where he kind of makes fun of the state of California, because California is arguing that magazines are not arms. And he's like, well, that's very interesting because under the definition of firearms and the firearms related code of the state of California is where you talk all about magazines. So if they're not firearms, why are you regulating magazines and talking about magazines in the part of the California Criminal Code dealing with firearms if they're not firearms? And moreover, he goes on to say another amusing thing where he points out that indeed, For those of you in California, you know this well. The California handgun roster has certain requirements that you have to have a type of magazine that without that magazine, it cannot fire. So he's like, well, therefore in California, according to the handgun roster, issues, you can't even fire some of these newfangled guns without a magazine. So how on earth can you say a magazine is not an essential component of a firearm in California, for crying out loud? And I thought that was kind of amusing that Judge Benitez called out the state of California specifically by pointing out that on the one hand, in some sets of laws, you need to have a magazine that if you don't have a magazine in it won't fire. And then here you have an argument that says magazines are not essential components of firearms. And he caught that incongruity and used it against California to great effect. So, all right. Anyway, this is great news. Wonderful decision from Judge Benitez. This is going to go up on appeal in the Ninth Circuit. I'm sure that's imminent. I think they've already filed the appeal. We'll see what happens with the briefing, but I'll keep you abreast of this going forward. And again, I appreciate all your support here at the Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.